Okay, good evening, everybody. This is Nick Caracal, live from New York. Just give me some time to share the live link to some of the social media platform, and then let's start right away. Okay, so I'll be sharing some slides today because this is the topic that's specific to J1 visa holders and how we would transition towards H1B or green card if available. So again, marami nang naka-standby sa atin. So again, thank you very much for joining in today. Good evening in New York and in the United States, and maayong buntag in the Philippines. Okay, so can you just give me a feedback if my sound okay before I'll proceed? So again, hindi ko na maisa-isa lahat. So hi Janelle, Maria, Sir Ricky, and thank you for joining always pag may live ako. Randall, fantastic. Okay, so we will just wait for others though. So let's just give them 2 minutes and then we'll start right away. The reason being that I would want to have everybody start with my first 3 slides because that's where I'm gonna put in the foundation of what J1 visa is, and then kung ano yung fundamentals natin. Kasi later, pag may mga marami ng tanong, it all boils down to what is the basic principle of a J1 visa. No? Kasi marami ng mga variations ng tanong, but at least kung maintindihan natin ano yung pinaka-basic foundation or principle ng J1, we would be able to at least filter the type of questions that we will be talking about in the 1 hour live. So by the way, I will only be on live for 1 hour because may other commitment ako, but I'll try to answer as much questions as possible. So just like what I've done in the other Facebook Live, you could basically write your questions on the comment section, and then I'll try to answer them. So, Sir Rolly, thank you very much for giving me that feedback. So, I will now proceed. Hi, Janelle again. And then, good morning sa mga staff ko sa Davao. Thank you for your all support, guys. Okay, let's start. So, I'll start with the first few slides. So, I call this session transitioning from J1 to H1 or to a green card. So again, tanong lang kayo kung may mga tanong kayo mamaya, no? So just to remind everybody that this is only for information dissemination purposes. Even if I will try to answer your question, generally speaking, it does not create a lawyer-client relationship. And if you would want to have your case being discussed, I would recommend that you consult an immigration attorney so that you will be guided accordingly depending on your situation. Okay. General concepts. Okay, so just like what you know, especially kung marami tayong mga J1 visa holders na nanonood ngayon, a J1 visa is basically, right? So you sign in with your J1 sponsor and you actually committed to them or to the program that, hey, I am willing to participate in this type of program, but I am also willing to go back to my home country as soon as the program is finished. So I would presume that when you sign the J1 program, you are very aware that your stay in the United States is only very limited for 5 years, of course, unless you are not subject to or if you obtain a waiver. So again, we'll go over that details, but let's just go over the principles of a J1. So maraming mga professions that fall into this, that includes doctors, professors, but for purposes of this presentation, we'll focus on teacher issues. Kasi maraming tayong nanonood na yung mga teachers now. And they've done great. That's the reason why they are in demand in the United States because of their work ethics and their knowledge and the effectivity ng kanilang pagtuturo sa United States. So, school districts love Filipino teachers. So, thanks for that and thanks for your service as well. Okay, so duration of stay, when you sign that J1 or if you got the J1 visa, you are allowed to stay in the United States, maximum of 5 years. But we are also aware that with the pandemic, some of you may be already on your 6th year, 7th year, and there is a rumor that they might be able to give another extension this year. But until and unless your J1 sponsor communicated with you that the Department of State will be giving out another 1 year extension, that still remains to be a rumor. But there seems to be a basis of that rumor because I've heard a lot from the people we've talked to na baka magbigay ng another extension. But don't take my word for that. Okay? So again, once you have the J1 visa or the J2 visa, you are allowed to enter the United States 30 days before your program start, or you can stay in the United States 30 days after your program ends. So again, when you are on a J1, you are not a working visa holder. You are a trainee and you are under the jurisdiction or responsibility of the Philippine government. So you are an exchange visitor. That's why when we talk about waivers later, the Philippine government is still in charge of you or is responsible of your welfare in the U.S., except when you are married to a U.S. citizen, or if you actually have a U.S. citizen child, then let's talk about the details of that. So dependents, as a J1 visa holder, you can bring in your spouses, you can bring in your unmarried child who are below 21 years old, and once they enter the United States, they may be able to apply for a work permit. So ito lang yung small tips natin. So I know very well that when you bring your minor children, right? So let's say they are 10-year-old or below 15-year-old, and some of you do not apply for their work permits because ang sabi nyo, hindi naman sila magtatrabaho. So pwede na silang hindi mag-apply ng work permit. But if you think about it, one of the reasons why you would want to apply for a work permit for them is for you to be able to obtain a social security number for them. And that actually gives you a lot of advantages kung meron silang social security, right? So you will be able to apply for their insurance or kung anumang other privileges or activities that you would want to bring them into that particular activity that requires social security. So I think other than the ability of your children to be able to work, one of the major consideration that you would want to take into consideration para mag-apply kayo ng work permit for them is for them to have their own social security number. Okay? So, restriction. So, generally, when you sign the J1 program, you are subject to the 212E because teachers in general are part of the skills lists in the Philippine government. And that's one of the two major factors that the government use to determine to put you in subject to the 212E. And we'll talk about what 212E means in a bit. No? So before you would be able to get another H1 or an immigrant visa, you need a waiver. No? So pag-usapan din natin ng waiver mamaya. But the commonly used ground for a waiver is the no objection statement that will be applied through the Philippine government and the exceptional hardship that you will be applying through the Department of State. So mag-apply tayo through the U.S. Citizenship and Immigration Services. But just take note lang, for people who are formerly married in the Philippines and who obtained divorce in the United States cannot apply for the no objection statement. The only ground for them for a waiver is to apply for exceptional hardship based on a U.S. Citizen spouse or a green card holder spouse. Again, summarize ko lang ha, paulit-ulit ko sasabihin and I will share in a bigger screen our time diagram on how this journey look like. Pakita ko mamaya. So, again, if you are subject to the 212E, 212E means that may tatak sa visa nyo or sa DS-2019 nyo na you are going home to your home country and stay there for 2 years before you can come back to the United States unless you obtained a waiver. Okay? So, may mga tanong din na, okay, assuming that we will not be able to obtain a waiver and we need to go home, saan ba kami pwedeng umuwi? Can we go to Thailand or in Canada or in Australia while waiting for the 2 years? Or do we have to go back to the Philippines? So the rule says, if you actually obtain your J1 visa in the Philippines, then you have no option but go back to the Philippines. So ang tanong, pwede ba kaming magbakasyon kung saan at pagbalik? Yeah, the government will look into your visa stamps and literally count the 2 years that you are physically present in the Philippines. So ang ibig sabihin, even if nagstay ka sa outside the US for 2 years, but 6 months of that is outside the Philippines, so kulang ka pa rin ng 6 months. So you still have to extend your stay in your home country. But there are some also teachers who are actually working in Indonesia or in Thailand, and they obtain their J1 visa from those countries. Then they also have the option of completing their 2-year home residence requirement in those countries kung saan nila nakuha yung J1 visa nila. Okay? So I hope that clarifies the confusion kasi marami kaming nakukuhang tanong on the consultations that I get almost every day. So kung kakukuha mo lang ng iyong J1 visa, then how do you know if you are subject to the 212E? So kung titingnan mo yung visa mo sa passport mo, there is a statement at the bottom part of your visa that says the bearer is subject to 212E. Or kung hindi naman kayo subject to the 212E, nakasulat doon that you are not subject to. And I'm actually sharing it here now. So lakihan lang muna natin yung screen. So doon sa visa stamp nyo, makikita nyo doon kung you are subject to or you are not subject to. So that's how you basically determine if you need a waiver or not. Then, let's talk about the J1 visa transitions. But before I go further, let me answer some of the questions here. So again, thank you for the marami-rami tayong audience ngayon. So please bear with me kung hindi ko mabasa yung tanong niya, no? Kasi marami-rami din. RG, my visa is not subject to, but my DS 2019 is subject to. What should I do? So that's a very difficult situation because kung i-apply ka ng employer mo, and then you will be submitting both the visa and the DS 2019. So by remedy, ang dapat mong gawin is mag-advisory opinion ka to really determine kung subject ka ba talaga o hindi. Because those instances happen at the embassy kasi siyempre magkakamali minsan ang embassy to give you a not subject to stamp but in reality you are. Or possibly din hindi ka talaga subject to the 212E and then ang stamp mo nakasulat that you are subject to 12E. So to give you a peace of mind, I would recommend that you apply for an advisory opinion. However, do not apply for advisory opinion nowadays because it seems like after the pandemic, I mean during the pandemic, when the Philippine government and the US government has really looked into the J1 visa program, and when the Philippine government changed their rules, and one of their justification is that ang daming nag-apply ng waiver during or before the pandemic. That's the reason why they changed the regulations. And then nagkaroon sila ng resume talks with the US government, and then nagiging stricto masyado ang pag-guard nila on the J1 waiver applications. So as far as I am concerned, or as far as ang alam ko, those who applied for the no objection statement after the Philippine EVP actually changed the rules, wala pa silang na-approve na NOS based on a US citizen child, or if they are married to a US citizen spouse or a green card holder spouse. So even the advisory opinion, I don't recommend that you apply that nowadays kasi medyo higpit sila masyado. No? So if you are still in the second year, then hold on to that application. But RJ, to answer your question, the best recommendation is for you to apply for an advisory opinion. Hello, hi Ma'am Faye. Ma'am Faye, good evening. Okay, so nagbabasa lang ako dito. Hello Emerson, and kumusta ang Ilagan? Ilagan pala, Ilagan City. Good morning. Is it a ground for not granting a J1 visa if you have a US citizen sibling and currently petitioning your parents as immigrants? So, not necessarily na hindi i-approve yung J1 mo because you have a US citizen sibling or relatives and so on. But ang embassy kasi, or let me step back, J1 visa is a non-immigrant visa. So when you go into the embassy and appear for your J1 interview, you really have to still give an impression to the officer that you have no plans of staying permanently in the United States. So they will look into your strong ties, no? Babalik ka pa ba sa Philippines or babalik ka pa ba sa home country mo, no? So once during the interview, if the officer have the impression that, oh, you have immediate relatives, you have parents, or you have siblings, or you have no work, or you have no investment in the Philippines, then iisipin niya na baka hindi na ito babalik. And the officer could basically use that reason to deny your J1 visa or J2 visa approval. So yun lang kasi minsan kasi yung ibang applicant sobrang excited to go to the United States on a J1 kasi mataas naman ang approval rate ng J1 or J2 in the Philippines, but sometimes they forget that a J1 visa is still a non-immigrant visa and they still cannot share that information or intention that they plan to stay longer or permanently in the United States. So I hope I answered that question, Dan B. So Rina, J1 teacher here and not subject to the 212E rule with pending 485. Okay, that's good. Need ko po ba i-maintain ang status ko as J1 while waiting sa approval ng 485? Or transition muna sa H1B in case di ako ma-approve sa 485? What's the best option po? Last year ko na sa J1 visa. So ma'am, it really depends, no? If your pending 485 is based on you are married to a US citizen, then ang recommendation ko, this is how I advise clients though, no? So if they are married to a US citizen and the US citizen says that, hey, I don't mind my wife or my spouse leaving work because I can support them financially, then the answer to your question is yes, no? But if your pending 485 is based on an employment base, kasi may mga school districts na rin na nagpa-file na ng adjustment of status for their teachers, then ang recommendation ko is no, because once you do that, then the officer might actually accuse you of actually taking advantage of the pending 485 petition by the employer, then inabandon mo na yung J1 visa mo. The problem with the employment base though is the officer could still find reason to deny your application or any other 485 application, even on a family base, no? But the good thing about 485 based on a family, kung ma-deny man siya or kung matagalan man siya, you are married to a US citizen, there's a lot of ways to really file an appeal or file a motion or refile your application because it is a family-based petition. But once it's based on an employment-based, ang laki ng complexity na mga tasks na gagawin before you could even file your green card application. So, I'm not so sure, Rina, kung saan ba galing yung 485 mo, kung family-based ba siya or employment-based. Let's talk about kung family-based siya. Kung your spouse is a US citizen and he doesn't care about you not having work, then yeah, you may stop with your J1 and just continue and wait for your green card application. But if your spouse is a green card holder, I do not recommend that you stop working on a J1. Kasi baka may makitang ground for not approving the green card yung ang officer, then wala ka na ngayong work. No, but if it's employment-based, the more that I will keep your J1 kasi baka mas marami pang mangyari while pending yung J1 485 application mo. Your thoughts and comments about some Filipino teachers are asking for 5K pesos commitment fee and they are not licensed to collect fees by the POA. 5,000 pesos commitment fee? I'm not so aware of what that means, right? But the rules is very strict on the Philippine government side that there should be no fees collected from the applicant and that the employer should actually pay the H1B related expenses. Magnolia, may update po kayo sa waiver for the teachers ng employer ay under the Bureau of Indian Education. Unfortunately, Magnolia, though, there is still no movement on that initiative. The Indian Education is actually focused on the Project Teach. The concept of that Project Teach is basically to encourage natural-born American citizens to teach, and they actually giving funding on that. So most states actually acknowledge that maraming kakulangan ng teachers in the US, while they entertain the idea of them being the interested government agency to petition waivers for specific schools, pero hindi ganun ka-significant ang improvement or development in that regard, unfortunately. Randel, nagpakita na po ng interest ang head of school na gusto nila akong ipaste dito sa dito, kahit alam nilang under J1 visa at subject to 1 to E. Ano po kaya ang pwede kong magawa? Ang school po ay non-profit school at special education po ang service na binigay ng school. Willing po ang school na makipag-communicate sa inyo with regards to this matter. Okay. So, ma'am, thank you for that. That's actually my last slide before this for this Facebook Live. But sagutin ko na yung tanong mo. If you really would want us to talk to your school district or HR, I recommend that you will send a message to I Dream America. We do that with most of the schools that we've assisted. So we present to them what your options are if you are subject to the 212E. No? So the good thing is they already shown that they are interested in keeping you. But because of the fact that you are subject to the 212E, and if you do have no ground for a waiver, medyo mahirap, no? But again, if in the worst scenario, H1B will not be available for you, we could still convince your school district to start your green card application such that pag uwi mo ng Pilipinas, kahit naghintay ka doon ng 2 years, at least pagkatapos ng 2 years na yon, chances are you will have an interview date at the embassy for your green card visa, for your immigrant visa or your green card application na. Hello, Sir Arman. Good evening. Okay, Sir Jed, can the H4 travel to the other state by plane without the H1B? Example, for example, kami with my wife, pupunta ako. Yes po. So, generally, hindi naman sila nagtatanong when you travel inside the United States. When you go into the airport, the purpose of them asking for your passport is for identification purposes, right? It's very rare, and there's only few states that reported na they will randomly ask for visas or proof of lawful stay in the United States. So California does random checks, Arizona does too, and I didn't hear in New York if they are actually randomly checking. So to answer your question, yes, they can safely travel all over the United States. And of course, you may bring your passport, but if the question is, are they looking for your H1? Kung hanapin ba yung titignan ba yung H4 visa mo at kung hahanapin bang H1 whenever you travel? No. Don't worry about that. They will be able to travel within the United States even without the H1 accompanying them. As po, if nanganak ka dito, need po ba mag-apply ng dual citizenship? Not necessarily. Okay? So, if you nanganak ka rito, yung anak mo automatically become a US citizen. Now, if you want them to actually have a dual citizenship, then you need to call the closest Philippine consulate or embassy, and then you can apply for dual citizenship there. So ano bang purpose doon? Ang purpose doon is for you to be able to apply for a Philippine passport for your child, and at least kung uuwi ka sa Philippines, hindi ka magbabayad ng alien tax. So yun lang yung advantage ng applying for dual citizenship for your child. Sabi po ng district namin na they will request a government agency for an IJA waiver. Is that possible? So, it's actually one of the slides. Unfortunately, for teachers, I assume that teacher ka-ish. No? The only interested government agency that could help you is basically the Department of Education and the Bureau of Indian Education. Unfortunately, those two agencies do not support the waiver as of the moment. There are initiatives to actually influence the BIE to be an IGA, but again, just like what I mentioned a while ago, wala pang significant movement in that regard. Pwede po ba maghanap ng EB3 visa sponsor ang J2 habang nasa US? Maghahanap? Yes. But if the J2 is subject to the 212E, pareho pa rin siya ng process ng kanyang J1, right? Kailangan pa rin niya ng waiver. Now, if your J2 is not subject to the 212E, then he or she might be lucky to be offered an H1B or a green card kasi hindi nga siya subject to the 212E. Okay? Michelle, so dalawang questions na lang and then I'll proceed with my presentation. Okay? Kapag po ba first visa is subject, good for 1 year, at yung second visa nung nag-renew for second and third ay not subject, hindi pa ba waiver o pwede ng diretso ng H1B? So, here's the thing. When you applied at the embassy at ang tatak ng DS 2019 mo or visa mo is you are subject to. Ngayon, pag nag-expire yon, pumasok ka sa US, nag-expire yon, then you will be given the new DS 2019. Generally speaking, walang markings yung bago mong DS 2019. So, malalaman mo lang yon kasi pag lumabas ka, number one, pag nag-expire yung visa mo at nabigyan ka ng bagong DS 2019, there is no obligation for you to go out and get a new stamp. You could basically stay in the United States and still be lawfully present because you have an extended DS 2019. The only relevance of getting a new visa stamp is kung lalabas ka ng US, hindi ka na makabalik kasi nga expired na yung dati mong visa. So ngayon, magpapaschedule ka sa US Embassy to have your stamping based on the new DS 2019. Only then, you will be able to learn kung you are still subject to or not subject to. Then again, to the second aspect of your question, is it now safe to apply for H-1B? I don't think so. If your initial J-1 visa is subject to, chances are your 2-year and 3rd-year extension is subject to. But if you would want to get the peace of mind, then you can apply for an advisory opinion para confirm kung you are subject to ka talaga or not subject to. Okay? Yun lang yung remedy mo doon. Maria, with your help, I am now on H-1B visa. Ma'am, yeah. Okay, thank you for watching, ma'am. My question is now is, if I transition to green card by marrying a resident, I wonder what should we do? Ano po ba magiging timeline if mag-apply na kami? Ma'am, I recommend that you send us a message, no? Kasi kung resident siya, fortunately, current pa ang spouses of a green card holder. So you could basically apply for green card anytime. And you don't need a waiver. You have a very smoother transition towards your green card. Timeline now, if you will apply for the green card, 5 months later, you will have your work permit. Though you don't need that because you have your H-1B still valid. But, and then 9 months, 1 year later, you will have your green card. So congrats in advance, ma'am. Talk to you soon. Jed, can the age for travel to the other state by plane without the... So yes, I think nasagot ko na yan kanina. Pwede kang mag-travel alone. Ria, hope all is well with you. Question lang po, what is the best option po to complete the 3-year of J1, then look for H1B sponsor to extend 2 more years, then pursue the H1B? Okay, so it all boils down to the principle, right? If you are subject to the 212E, then you need a waiver. If you are not, then H1B or green card are options, available options for you. So ito na nga yung graph natin. Okay, tanggalin mo na. So general principles. You are a J1 visa holder. You look into your visa stamp, nakita mo na you are not subject to 212E. No? So ibig sabihin, applying for H1B is an option for you. Applying for a green card is available for you, or you don't want the two. You would apply for another visa kasi mas gusto mo yung mag-O1, extraordinary ability, pwede rin yun. Hindi ka hahanapan ng waiver kasi nga you are not subject to the 212E. However, if you are subject to the 212E, I'm now on the right side of my presentation, then you need a waiver. Ngayon, kung meron ka ng waiver, then para ka na rin walang subject to the 212E. Then it becomes available for you to get an H-1B, a green card, or other visas that you want to apply. However, pag subject to 212E ka, ito yun. Now, at wala kang waiver, then you are not in a better position because you will be confronted with the decision of uuwi ka ba ng 2 years para makomply yun. And once you comply with that, then you can apply for another H-1B 2 years later, or yung employer mo, pwede na mag-start ng green card application mo, and then maghintay ka ng 2 years outside the US. By the time na makomply mo yung 2 years, chances are baka may interview ka na sa embassy. But that's the graphical presentation of our discussion today, and I hope that gives you a picture of where you belong. Okay? Ngayon, isa-isahin natin yung mga slides na yan. By the way, before I proceed, please subscribe to my YouTube channel, The Cartel US Immigration TV. Nandito naman sa Facebook lahat ng Facebook Live ko, pero mahirap hanapin. So at least with YouTube, makikita mo siya sa playlist or sa video lists. Okay, balik na naman tayo dito sa slide na to. And pasensya na kung yung slide ko paulit-ulit because I really would want you to get that picture in your mind para it would help you in your decision-making process kung anong gusto nyong gawin as far as your journey in the US is concerned. Again, uulitin ko na you only need, you only need a waiver if you are subject to 212E. Ngayon, kung hindi ka naman subject to the 212E, then don't worry about the waiver. You can just basically discuss with your employer to apply for H1B or your green card. Okay? So ulitin ko ulit, if you are not subject to 212E, ano bang available options for you? You can apply for H1B, you can apply for immigrant visa, or you can apply for other visas. If you are subject to the 212E, waiver is needed before you can apply for H1 immigrant visa and other visas. So post na naman ako dito kasi maraming versions yung mga tanong dito at magpapasa ako ng mga tanong, right? The common questions that we actually receive from this slide is, attorney, yung asawa ko or yung anak ko inoferan ng kanilang employer ng green card or H1B, qualified po ba sila? So again, if you are subject to and they are also subject to, then they need a waiver before their employer can file an H1B for them or a green card for them. So talagang babalik tayo doon sa waiver if they are subject to the 212E. Ace, J1 teacher daw, Arman sir, for J1 teachers daw po yan, hindi po hospitality enters. Okay. Sagutin na rin kita, Ace, no? Generally kasi, pag J1 pa rin, yung sa hospitality industry, right? But 99% of the people who work in the HRM industry are not subject to. So, J1 pa rin kayo. So, pag kunwari, pumasok kayo dito at inoferan kayo ng H1B, then you will be eligible. Or if you meet someone and then US citizen yon or green card holder yon and they promise to get married and then file for a green card, then pwede yon, and that's the journey for them. So, mas better ang posisyon ng mga J1 HRM kaysa sa mga J1 teachers, doctors, or researchers and all that. I am on my 5th year po and I have an ongoing hardship waiver application which is now forwarded to the US. Is there any alternative po for us to be able to stay like IJA waiver? Again, just like what I mentioned a while ago, the IJA waiver is not available option as of now. So I actually had a group of teachers who were mad at me because I'm not an advocate of an IJA. So I actually clarified it with them. As a Filipino, I also wanting other Filipinos who would get better opportunities in the United States, but I cannot use social media and actually give false hope to say, yes, IJA is available for you. In reality, alam kong hindi naman siya ina-accommodate ng Department of State, Department of Education, or the Bureau of Indian Education. So, again, I really hope that the two agencies will open up soon and will start accepting IJA waiver applications, but as of the moment, hindi pa talaga sila nag-a-accommodate. So, Facebook user, 5 years po talaga ang J1 or 3 years po? Here po sa Missouri now on my first year. So, again, just like what I said a while ago, initial mo is 3 years. Then, maximum stay mo is 5 years. So, ibig sabihin, pag mag-expire na yung 3 years mo, your J1 sponsor and your employer may file an extension for you. So, just continue to work excellently in your job, so your employer or your J1 sponsor will offer you a 2-year extension towards the end. So maximum stay mo is 5 years. Genesis, possible po ba IJA waiver? Again, unfortunately, IJA waiver is not available. Someone po, RG, na J1 visa na subject po sa visa and subject po sa DS. Nagpa-advisory opinion siya using a blank DS na wala pong naka-indicate na subject siya. Para daw pa maging not subject. She declared po na lost ang URIG DS po niya. Is this type po ba na that would be give you? No, even if nawala yung DS mo, right? Or even if the Department of State has records of all your DS 2019, no? So your J1 sponsor creates the DS 2019, and once they create, they are using the Department of State system. So they will have a record of all your documentation as far as J1. So I would rather tell them the truth because pag naunahan ka, baka the agency will accuse you of fraud or misrepresentation. Little girl, let us say po may pending application ka ng exceptional hardship dito sa US at gusto mong umuwi muna habang naghihintay ng result. Posible po ba 'yon? Deep naman po mapiktuhan ang application. So, ma'am, it depends, no? On how you actually prepared your exceptional hardship application. Kasi sa case namin, one of the factors that we actually use is the safety. Again, hindi ko alam kung anong ground ng ano mo, hindi ko alam kung ano yung ground ng pag-apply mo ng waiver. If this is based on a US citizen child or if this is based on US citizen spouse. Now, one of the arguments that we actually use is depende kung saan sila pupunta sa Philippines. Now, if the province or the city that you will be visiting is medyo high crimes or compromise yung safety mo or safety ng partner mo, and then you actually use that as your argument, but at the same time, teka muna, umuwi muna ako para magbakasyon. Kung ako yung officer, then I will use that information to say, then there is really no real threat on your safety and your well-being, no? Kasi naka-afford ka pang umuwi doon. So again, it all boils down to what factors did you use when you apply your hardship factors. Kasi kung magko-conflict yung travel mo and you're also claiming wellness and safety concerns, then it might be an issue. Pero kung wala naman, maybe not. So, but then again, on all hardships that we prepare, we use the safety and wellness as part of the argument. Jacqueline, I'm on my 4th year already, and I have a son who will get into college this coming year, which is 5th year. I want him to stay to continue his studies, even if we will go back for 2 years rule. Is that possible? So, there is what we call, you could actually apply for IGA waiver, and this is only the exception where I talk about IGA, no? So for children turning 21 and want to continue their studies, the Department of State can act as the IGA for them to be able to stay here. But based on what we see sa mga applications na na-approve sa category na yon, no? And when I say category, for children turning 21 who wants to continue their studies in the US, are those children whose parents are still in the running towards their 4th year or 5th year. So, what I'm trying to say is, kung kayo patapos na, then chances are hindi magagamit yung IGA because the US government will actually say, then go home with your parents. No? And then you are subject to the 212E. I will not say that do not apply because there might still be a chance that you will be approved, especially in cases of children na achievers, right? They got actually grants for their scholarship and they are actually an achievers in their school. Maybe convince the Department of State that you just want to take advantage of the better opportunities for your children here. But generally speaking, kung patapos na yung J1 duration ng parents and then magta-turn 21, medyo nadidina yun. But again, I'm not stopping you from applying for IGA using the Department of State as the interested government agency, and then argue your case and hope that you will be approved for the waiver for your children. Okay. What happens if a J2 visa under 21 marries a US citizen? Subject pa rin po ba? So, again, you can determine if they are subject to or not subject to, no? Kasi nasa passport yon, nasa DS 2019 yon. Ngayon, if they are subject to and they marry a US citizen, then they still need a waiver before they would be able to apply for their green card. Genesis, wala po bang chance to get a waiver through the research na sinasabi ng CFO? Wala pa pong guideline ang CFO with regards to the research. And it's unfortunate though, no, na they actually promised that last July last year. And unfortunately, naabutan na ng almost June where majority of the J1 teachers who are on their 4th year, hindi pa rin sila nagbigay ng bagong guidelines. But as of the moment, wala pang J1 AVP guidelines on research or special projects. For J1 exchange visa for 1-year program, pwede po ba mag-apply ng working visa again? If they are not subject to, yes. If they are subject to, they need a waiver. Sir Alexis, hello po, Cagayan de Oro. Thank you po. Taga Cagayan de Oro pala ako, no? So I graduated from Xavier University for my Bachelor's of Law. So okay, sagutin ko lang si little girl and then I'll proceed with my presentation. Attorney, let us say may pending ako na application, exceptional hardship at tulungan ako ng principal ko sa district namin, i-request for extension of stay sa DOS. Ma'am, ang exceptional hardship kasi is a personal application and your employer cannot help you with your exceptional hardship. So exceptional hardship only applies to when you are married to a U.S. citizen or a green card holder, or if you have a U.S. citizen child. And your employer giving you a job offer or anuman cannot help you. Okay? So again, kung if you wanna talk to your employer, then I would recommend that you explore the employment-based options. Either they will start the green card application for you, uh, yun lang. So again, I'll proceed now with my presentation, okay? So, available waivers. So, ang sinasabi ko nga kanina, the common grounds na ina-apply ng waiver, especially for the Philippines, are exceptional hardship or no objection statement based on if they are married to a U.S. citizen spouse or a green card holder spouse, or if they have U.S. citizen child, then they use those two grounds. But again, unfortunately, with the existing guidelines ng EVP Philippines, chances are you will be denied if you're gonna apply for the no objection statement now. So it seems like your only best option is to apply for the exceptional hardship. But unknown to others, there are still not so common grounds na ina-applyan pa rin. So in the Philippine government or your home country, no? Na meron pa silang mga humanitarian reasons. So these are people who nagkasakit, nagkaroon ng cancer, or life-threatening medical condition. So I don't know how people on their own submit the application and give a compelling argument, but we have cases which been approved on humanitarian reasons at mahirap siya, no? The EVP will really look for evidence of pag sinabi mong I will not be able to afford my medical costs, expenses, then naghahanap talaga sila ng proof of expenses either paid by your insurance or not. So if you're actually claiming that it is life-threatening and there is no available treatment in the Philippines, then they will actually ask you for evidence of your claims. Kung talagang wala pang available treatment in the Philippines, or if the treatment is available na hindi mo kaya kasi wala kang insurance, or the cost of treatment is too high and the only option if you go home is you will die, no? So yun, humanitarian reasons yun, no? You don't want to go there. So ang masasabi ko lang talaga sa mga nagko-consult sa amin, the only happy grounds to apply for a waiver are you are married to a U.S. citizen or a green card holder, or if you have a U.S. citizen child. All other grounds is a little bit difficult and it's a sad side of your journey, no? Kasi ito yung sinasabi natin, humanitarian reasons. Either nagkaroon ka ng malubhang sakit, or you've been persecuted, or you've been abused, and so on and so forth. So that's the humanitarian reason ground. Now, on the US government, the only ground talaga na pinupuntahan nila is the interested government agencies, no? So, unfortunately for the teachers, that's not an available option for them because kagaya na sinabi ko kanina, the Department of Education or the Bureau of Indian Education are not processing or accepting waiver applications for the moment. However, kung may mga nakikinig sa atin na yon na hindi teacher, right? So, kunwari, sa agriculture, the Department of Agriculture is still accepting or supporting IJA waivers for those people belonging into that area. Okay? So again, once you are not a teacher watching this live and you are subject to the 212E, then I would recommend that you consult with an immigration lawyer. Baka the agency that you belong to are considered active as far as filing your IJA waiver. So sa teachers lang talaga tayo medyo sad news kasi hindi pa sila talaga tumatanggap. So grants of waivers, again, if you're the ground of your waiver is U.S. citizen child or a green card holder, U.S. citizen spouse or a green card holder spouse, at na-approve yung waiver mo, then you can apply for H-1B, or your spouses could file an immigrant petition for you, or if your school, kasi minsan because of money matters, yung immediate relative mo spouse cannot file a petition for you, but your school district is willing to help you out, and they would basically file your green card application, then that could also be possible. We have clients though na sobrang bait ng school district that even if they are married to a US citizen, they still would want to sponsor the cost of filing their green card application even if it's based on the family base. So, swerte yung mga tao na yun, no? However, ito yung minsan maraming nagkakamali. They have the ground na meron silang US citizen child. At because akala nila na they would be able to get a waiver based on the US citizen child, they don't look for employers. That's pretty much fatal because your US citizen child cannot file a green card application for you, unlike the US citizen spouse or the green card holder spouse, because as of the moment, current ang F2A or spouses of a green card holder. So what I'm trying to say is kung ang basis ng pag-apply mo ng waiver is a US citizen child, then pag-apply mo pa lang ng waiver, maghanap ka na ng employer mo who will be offering you an H-1B or ang employer na meron ng approved labor certification. Kasi kung wala pa silang labor certification, it could take 2 to 3 years before their labor certification can be approved. By that time, you are already out of time. So, once your ground or your basis of applying for a waiver is based on a U.S. citizen child, and that waiver application is approved, then the only logical option for you is the H-1B route, not the immigrant visa. Okay? So, before we gonna talk about H-1B, let's read some more questions here. Okay? Ports, ang J1 visa ko ay not subject to 212E, pero ang DS-2090 ko ay not check at subject to. Anong chances na H-1B application? So, again, you could take your chance, no? Because there are cases where H-1B has been approved, but the officer reviewing your case could basically reach out to the Department of State and ask for an advisory opinion kung talagang subject ka or not subject to ka, no? So that is still possible, no? But if you're asking a question of, are there cases where the H-1B stamp is not subject to, but your DS is not, is stamp subject to, and they got approved for H-2B? Yeah, there are still cases that get approved. But then again, it's a risk that you are taking because down the road, it could still come back to you to say, at the end, you are actually subject to, no? So, but it's a risk. I would recommend that you consult with an immigration attorney to really assess your situation. Hello, Sir Marlon and our teacher friends in the US Virgin Islands. Magandang gabi po. Maria, July 7 po ang final nila attorney. Then July 21, okay na po. Approve na and I paid. Okay. Ma'am, congratulations. Sam Jane, not related sa H-1 visa. Sorry, just want to ask. My tourist visa was revoked. Was it because my pending invitation? Okay, so ma'am, I apologize now if I would not be able to answer that question because it takes a lot of time to discuss. If you would want, I actually covered that in one of my YouTube, Facebook Live recorded event. Meron akong topic doon about the tourist visa application and how a pending immigrant application affects or does not affect your application during the interview at the embassy. So, Jojo, my wife is a J1 visa holder. I'm on B2. If I find a company willing to sponsor an H1 for me, how will that affect my J1 status? No. And if you get lucky to find an H1B sponsor, then go ahead, boss. I would recommend that you pursue your own H1 as opposed to entering the United States on a J2. Baka kasi maging subject ka to 212E. No? But be very careful when you enter the United States on a B2 and then change your plan to apply for H-1B during the first 90 days because you might be found committing fraud. No? So, again, recommendation ko, you consult with a lawyer so that you will be guided accordingly. Matagal po ba mag-apply ng waiver? Kung J1 po kami, kailan ang proper time to get a waiver? So, very good question. If you're applying for the NOS, then the requirements will ask you that you have to wait for your second year. So, i-complete mo muna yung 2/3 mo before ka mag-apply ng waiver. So, but you don't want to apply for a waiver kung naghihintay ka rin ng 4th at saka 5th year extension mo. So, the best way to answer that is, hintayin mo muna yung extension mo before you will apply for a waiver. Okay? But, if your basis of applying for a waiver is a U.S. citizen spouse, then, if you can file the waiver anytime, right? But, if you apply for a waiver based on the exceptional hardship of a U.S. citizen spouse or green card holder spouse, and you just recently got married, then be prepared of being challenged, and you will definitely receive a request for evidence challenging you na, hey, where is the hardship kung you are just married 2 months before you apply for the waiver. But there's a way to argue that, and heads up lang that you will be facing the challenge. So again, I think I didn't answer quite now. So the question, the best way to apply that, ma'am. So again, if your application is based on NOS, the best way is to wait for your 4th year and 5th year to apply. But if it's based on the exceptional hardship, if you are on the second year and you're married to a U.S. citizen, then you can apply anytime. But the best advice talaga is to wait for your extension to be approved before you apply for any waiver. Randy, if I go home with an expired 3-year visa with approved extension, may chance na mag-stamp 212E except if mag-renew before going back to the US. So, as sinabi ko na kanina, no? So, the new DS 2019 chances are walang stamp yun. You will only get to know that you are subject to or not subject to once you appear for interview for the extension at the US Embassy. Jason, do not have to want to stamp po. Can I possibly get another visa stamp in my passport and see if I am still subject to? The thing is, only the embassy can give you a stamp. So the only way for you to know if you are subject to will be to go home and get that stamp at the US Embassy. Okay? So, huwag kayong magtaka na ang bago nyong DS 2019 is walang stamp. That's the general practice. You will only get to know kung you are still subject to 212A o hindi pag umuwi kayo sa Philippines, and then magkaroon kayo ng interview or appearance at the embassy. Just give me a second. Okay, another thing. 2 more questions and then I'll proceed with my slides. No? So I only have siguro less than 10 slides remaining. After po ng J1 visa program ko, pwede ba mag-apply ang dating J2 as J1? At ako naman ang magiging J2 niya? So, this is an interesting question in the sense that it happens to majority of the teachers. And I actually look at that as, I've talked to a lot of school districts, and those school districts only get to know that the best and the fastest way to bring in teachers is through the J1 visa program. But 5 years later, they get to realize na ang hirap pala because they get to learn to love the teachers. But here comes the reality of them going home and then lose that relationship that they built for 5 years. So sa question mo ngayon, is it possible po ba na magbaliktad yung role nyo when you come back? The answer is yes. Practical reason, is it advisable? I don't think so. Because kung galing na pala kayo ng J1 or J2 and you already established the relationship with your employer and you have no ground for a waiver, ang recommendation ko, Prinzer, is to influence or at least talk to your employer to say, while we are away, can you start the green card application for us? Or, umuwi kayo, naghintay kayo ng 2 years, then H1B can be approved in a month. So, kung you still have maintained that relationship and you will be able to actually tell them that, hey, we are about to complete our 2-year home residency requirement. If you still have an opening for us, can you process the H1B for us? So, what I'm trying to say is, I don't recommend you getting another J visa. Ang recommendation ko is to get another H or another green card application, green card opportunity before you go back to the United States. The next question will be, wala naman kaming available information kung sino yung mga employers offering H1 or green card. So that's true too. But again, if you are already here on a J1, your best option is to communicate back to your own employer and ask them if they are willing to file an H1 before you come back, as opposed to getting another J1. No? So sa mga teachers na unfortunately will not be able to get a waiver, and if you have a very good relationship with your current employer now, ang recommendation ko talaga is to have or to start a conversation with them. And if you have difficulty getting that across, you can reach out to us and we will help you communicate or explain to your HR or to your school district how this works, no? Kung paano ba simulan ang green card application nyo, where you are going home and wait for your 2 years, or how to apply for the H1B when you are about to come back, no? So we've done that to a number of school districts, and we've received positive responses so far. So we could help you in that regard. Okay, last na lang, then I'll proceed with my presentation. Christine, alam mo, J1 visa kayo may 4th year. Meron po ba kayong feedback about application in OS? Ma'am, do not apply for NOS now. Chances are you will be denied. Okay, so H1B. Let's talk about the nature of the H1B. So, lakihan ko lang muna to. So again, H1B is for specialty education, specialty occupations where most of the teachers are eligible for H1B. Now, so it only requires a bachelor's degree and then an approved labor condition application. So again, if you're a teacher, don't worry about that. Chances are you will belong to or you will be eligible for H1B. Yung dependents nyo will be called H4. The only disadvantage of an H4 is they cannot work, unlike the J1, J2 visa condition. No? And then on H1B, there are two types of H1B. The cap exempt and the non-cap exempt. So for the cap exempt, there are only 65,000 visas available per year. For 2022, the employer registration is open on March 9 and it ends on April 4. So it's a very close, strictly regulated registration for employers, no? But most of the time, these are used for private employers. So sa mga teachers na nakikinig, if you belong to the public school system, chances are you might be eligible for the non-cap exempt. Now, so what does that mean? So again, kagaya ng sinabi ko, if you are applying for the H1, kasi nga mabilis siyang i-process, in 1 month, pwede ka na ma-approve. But generally, you will be subject to a lottery kasi nga mas maraming applicants kaysa visa numbers available. Pero if you are a public school teacher and your school district is affiliated to a higher education or meron silang memorandum of agreement for a non-profit agency, then chances are they will fall into the cap exempt. Ang ibig sabihin doon, hindi sila maghihintay ng March or April to be able to file for teachers or employers. They can file teachers anytime. Yung non-cap naman, again, kagaya ng sinabi ko, 65,000 available visas, 20,000 available for the master's degree. So, for special education teachers, most states require advanced degrees, but may mga states din na hindi nila requirement ang SPED teachers to get a master's degree. So, again, if you think that your school district is willing to file an H1B and you are not subject to the 212E, or you already have obtained a waiver, or kung nasa labas man kayo ng US, nasa Philippines kayo, and you've heard that your former employer is willing to file an H1B for you, but they don't have an idea of how this works, we can help you. You could basically just send an email to them and copy us and set up an appointment so we could basically present to them how this transition from J1 to H1 or green card works. And we've seen success doing that for the last 2 years. Okay, green cards, again, when you heard about green card holders or permanent residents, they are the same and they are used interchangeably. No? And once you get that green card, if it's based on employment, you will basically receive your 10 years. There's no requirement for you to renew that because you will be eligible for citizenship anyway after 5 years. But if you are getting your green card through merits, may mga nakakatanggap ng 2 years, may nakakatanggap ng 10 years. So, how does the distinction apply? So, ito lang yun. If at the time ng interview nyo, you are already married for 2 years or more, with your green card holder petitioner, US citizen spouse, or green card holder spouse, then chances are you will get your 10-year green card. Kung hindi 10-year nakuha mo, ask an immigration lawyer to help you out, to argue that you are entitled to the 10 years instead of 2 years. However, pag the time ang interview mo, you are still married less than 2 years, then you will receive a 2-year green card. Okay? Now, I only have 3 slides left, so let's read more questions. Then before we'll talk about risks. Sir Lorenzo, pwede bang mag-recruit at mangolekta ng pera sa mga applicants natin sa US and J1, J2, or H1B? J1, J2, yes. There are rules that allow the sponsor to collect directly from the applicants. For H1B, yon ang medyo regulated because the rule does not allow recruiters to collect from the applicants. No? Violations ba ito ng DS 2019? Not the 2019, but the H1 program in general. May RM, if wala na po akong criteria like not married to a US citizen, no child na citizen, and no critical illness, hindi po ba ako pwede mag-waiver? Unfortunately, hindi po. Now, there is a promise from the EVP Philippines to issue guidelines on meritorious studies, but as of now, we are still waiting for them to issue that guidelines. Ma'am Eileen, yeah, just like what I've said, the IJA for teachers is basically not available for now. Mark, is it possible tourist visa extended for another 6 months and found an employer to have EB3 visa? Is this possible? Or try the H2B visa not to expire? Mark, I would recommend that you send us a message because that's out of topic for now. And medyo critical kasi if you enter into the US now on a tourist visa. Now, be aware of the 90-day prohibition on changing your plans because if you violate that, you might be found committing fraud by violating the terms of your B2 visa. Ives, I'm on my 3rd year po and applied for my extension. Nag-offer po ng H1 ang district ko pero subject to 212E ako. Paano po ang process na pwedeng gawin? So again, if you are subject to, just like what I said a while ago, H1B is not an option for you. So, ang recommendation ko, ituloy mo lang yung J1 mo to maximize the 2 years. Hopefully, you will find a ground for a waiver. Maybe you will have children at that point in time. And then, maybe try to apply for the exceptional hardship based on the U.S. citizen child. Or if the EVP rules change, maybe you would apply for the no objection statement. Pwede pa po mag-intern ng J1 dati sa US as tourist kahit hindi nag-stay sa Pilipinas for 2 years? We will move to a different country this year. Okay, let's step back. Pwede ba mag-enter ang J1 dati sa US as tourist kahit hindi nag-stay sa Pilipinas for 2 years? Okay, if you already have the tourist visa and it was not revoked or canceled by the embassy and you were former J1 visa holder subject to the 212E, can you visit? Yes. But can you stay permanently? No, kasi kung kunwari, for purposes of conversation lang, no? You are formerly J1, and then you're subject to, fortunately, meron kang tourist visa, you entered the United States on a tourist, and then for purposes of conversation, you got lucky, you got an offer from an employer. They will offer you H1B, hahanapan ka ng waiver. They will offer you for a green card, hahanapan ka ng waiver. You will file for an extension of your B2 tourist stay, hahanapan ka ng extension. But to answer your question, can you enter the United States? Yes. Can you change your plans? Most likely no. Okay? And at that point, I would recommend that you consult a lawyer. Magiging grounds pa ng cancellation ng J1 visa if ever nabuntis si J1 visa holder while J1 po siya, or if ever hindi po i-cancel, pwede bang gamitin as exceptional hardship? 2 questions, right? The first question is, pwede bang gamitin ng J1 visa sponsor ang ground na nabuntis ka? Yes. If you actually see, and I've seen a lot of contracts that actually stipulates na pag nabuntis yung applicant, the J1 sponsor may cancel their J1 visa. The rationale of that kasi is being buntis or pagpanganganak, if it will actually hinder from you from doing your job, then you are actually violating the terms of the J1 visa. And on that ground, the J1 sponsor can cancel your J1 visa on that ground. Is there discrimination? You can argue your case, but You could also look into that in the contract agreement between the two parties that you agreed with that. No? So, but to answer the question, yes, they can use that ground to cancel your J1 visa. Second, pwede bang gamitin exceptional hardship? Yung pagbubuntis, generally no. But once you give birth and then you have a US citizen child, then it can be a ground to apply either the no objection statement or the exceptional hardship. Now, your chance of approval depends on how you actually argue your case on the exceptional hardship grounds. Rain, kung J1 po ang transfer sa bagong employer as H1B, posible po ba na pwede mag-apply kaagad nila ang permanent resident or green card? Okay, if you are talking about the scenario where na-convert ka na talaga from J1 to H1, then the employer can apply for your permanent green card right away, assuming meron na silang approved labor certification. No? Pero people who are actually applying from J1 to green card, medyo be careful lang at the time of the interview because the officer could still find you committing fraud if they learned or determined that while you are on a J2, you already have pre-planned to apply for the green card. So be careful with that trap, no? Kasi again, on a J1, you actually committed to your sponsor that you are going home to your home country once your program ends. Bernie, some J1 visa holder with US citizen child have tried consulting with immigration lawyers, but they were declined on their case was not accepted because their US citizen child is healthy, no medical condition. What grounds po? And I agree with that, no? Pero, we have cases though na walang health condition but we still get approved because hindi lang naman health condition ang pwede mong sabihin na mahihirapan yung US citizen child. So when we actually accept cases based on a US citizen child, our premise is that, and the gist of our argument is the ability of the US citizen child to have a better life outside the United States depends on the parents' capability to provide for the child, right? Kasi with the current condition now of employment in the Philippines, if you are a teacher and the schools are closed, then how could you find employment? And if you don't find employment, paano mo bubuhayin yung US citizen child? Then you can argue your case on those areas. May family bang magtutulong sa'yo? Do you have economic resources to support for the child in the next 2 years? And if you are not lucky enough to get another visa in the next 2 years, then that number of years could be extended. So again, I recommend that you consult with us. You can get another lawyer to have a second opinion. But I agree with you. If your child has a medical condition, it makes your case stronger. But do you pray for your child to have a medical condition? Of course not, right? You would rather go home and stay there for 2 years and avail. But to answer your question, not necessarily, no? But if your child has a medical condition, it makes the case stronger and a lot easier to argue, but not in all cases, okay? Especially with the pandemic now. It used to be the rule that if the child has no medical condition, medyo mahirap. Mahirap talaga, no? But you have pandemic to consider as well. And with the pandemic, there are no opportunities for employment. Okay? Ria, will the child sponsor be informed by the immigration office if the J1 teacher is trying to seek for H1B sponsorship or already apply for H1B with a different sponsor? I heard kasi that J1 sponsor can terminate the contract if they find out that the J1 teacher is working on H1B with another sponsor. Question. Will the J1 sponsor find out that you already applied for H1B or another visa type? If they want to, yes, because they have your social security number, they have your DS3035 number. If they really are aggressive in looking into your records, they will find out. And once they find out, they can cancel or revoke your J1 visa. Okay? Ngayon, generally speaking, based on our experience, the J1 sponsor only get to know that you already applied for a change of status once the change of status is approved. So, ibig sabihin, pag kunwari J1 ka, nag-apply ka ng waiver, the waiver was approved, yes, your J1 sponsor will be notified. If you are a J1 sponsor not subject to a waiver, you apply for H1, your H1 is approved, yes, the J1 sponsor will be notified. So, yun yung general process on how the J1 sponsor is notified. But while the case is pending, will they be notified? Not necessarily. But the J1 will look into your records. Will they find out? Yes. And once they find out, they can cancel your H1 or J1. Jason, since my school district is very interested to sponsor us for H1 and I have a hardship application, is it possible to obtain H1 po ba? Though I am not sure if my waiver will be granted. Kung ako ikaw, I would wait for your waiver to be approved because the H1 can be processed in a month. So for as long as your waiver is approved, the danger kasi of applying for H1 while your waiver is still pending and you file for a premium process, then in the next 2 to 3 weeks from the time you file, hahanapan ka ngayon ng waiver. And then, you're only given X number of days or months to apply or to submit for a waiver. Eh kung wala ka pang waiver, din sayang din yung binayad mo sa H1B mo kasi nga mahal yung H1B. No? So, the better strategy for you is to actually wait for your waiver to be approved, then file for H1B premium process. I think that's the best strategy for you. Chess, magre-renew na ako ng R1 since naka 3 years na ako this month of March. Pag na-approve po ba, am I qualified to apply for a green card na? Yes. Assuming that, so again, I'm not so sure if you actually are a previous J1 visa holder because this is a J1 visa topic, but I assume that with this question, pumasok ka on R1 and you are not subject to any restriction, yes, you can apply for a green card anytime. Good day po, attorney. I'm curious po as to why J1 po ang kadalasan na J1 at not H1 for teachers since in demand naman po mga teachers sa US. Very good question, no? Wala ka lang pangalan sa Facebook. Just like what I've said ago, especially yung mga school districts in the remote areas in the United States, I give credit to the J1 sponsors who are very effective in communicating and reach out to school districts na, hey, if you need a teachers, there is a J1 visa program and we can process your teacher needs through the J1 program without cost on your side. So to answer your question, if I am the employer and somebody actually asked me to, hey, I can provide you with your teachers without much cost on your side and it's very easy to bring them over, then yes, I will get teachers on a J1. So mas alam kasi ng mga school districts yung J1 program as opposed to the H visa program or the green card application program. So ngayon, the last 2 years, we've seen na nag-stricto na ang Department of State. So then the school districts are being limited as to the number of J1 sponsors. So sakal lang nalaman ng school district ang H1B program. And besides, yung H1 kasi, required ang employer na magbayad on all the processing cost ng H1B. So magastos yon compared to the J1 na walang gastos yung employer and it's allowed by the rules. So to answer the question, kung ako yung employer, I would really prefer hiring teachers on a J1 as opposed to the H1B. So for the school districts that we've talked to, the only reason nila na bakit sila nag-offer ng H1 ngayon, number 1, wala na silang makuhang teachers on a J1. Number 2, because they want to keep their teachers who have been with them for 5 years and they offer them H1B if they have a waiver or they are not subject to 212E. Or kung talagang wala ng pag-asa at kailangan nilang umuwi and they still want them back 2 years later, they offer them the green card. So I hope I answered that question. Rain, if I am hired as H1B, pwede po ba agad mag-apply for green card? Yes, I think I answered that. Barney, what about persecution, asylum, hardship, waiver for LGBTQ? Since the Philippines has no law for protection. So, again, we have a lot of cases which been approved for exceptional hardship even on the ground of same-sex marriages. No? I don't believe that being on the LGBTQ community will actually be a ground to apply for asylum. I don't think that it is a ground or a reason to apply for exceptional hardship. But for the cases that we handle on the LGBTQ community, we still use the fact that there is no protection for the LGBTQ community going back to the Philippines, and it basically destroys the marriage that they know of in the United States because, again, the marriage is recognized in the United States. But once they go back to the Philippines, there is no marriage life that they talk about. So we use that argument, and we've been lucky so far. Michelle, what is NOS based on humanitarian ground? Okay, so ma'am, na-explain ko na yun kanina, this is basically based on people having developing cancer or life-threatening medical condition. If you could go review this Facebook Live in a bit, I actually talked about that extensively a few minutes ago. Okay, Precious. Precious, tanong ko lang po, yung conditional green card po, mag-i-expire this August this year. Pag mag-divorce po ba, can I affect my renewal? If we have handled cases where hindi pa finalize yung divorce, and then we actually notify the USCIS that there is an pending divorce, and then once that's finalized, you can apply on your own. So don't worry. If you can still prove that it was a good faith marriage, you can still get your 10-year green card. So tapusin ko lang itong two slides ko, and then I'll answer the remainder of the question, and then let's end the live kasi 10:15 na pala. Okay? So the risk, and this will be the last topic of my presentation today. Okay? Risk. Balik lang natin. The danger of applying for a waiver and then matatapos na yung visa nyo by June. And majority of the teachers are hesitant to apply for the waiver because may rumors nga na magkakaroon pa ng extension because of the COVID. But they are also running out of time because the waiver applications are now being approved 6 months to a year. And then if they will apply for a change of status from J1 to tourist visa to be able to maintain status, then definitely they will run out of status. No? So, unlawful presence. So, if they will not be able to get the waiver approved and hinahanapan ka na ng waiver before they will approve your extension or change of status, then chances are you will be incurring unlawful presence, no? And if you are not married to a US citizen, dangerous yon, fatal defect yon. So I really recommend that if your ground is based on a US citizen child, then I would recommend that you process your waiver the soonest time possible because you are running out of time. Working without authorization. Of course, if you are in a J1 and your J1 expires in June, you change to a tourist visa or a student visa pending the approval of your waiver, you cannot legally work because your J1 visa expires by June. At that time, you are no longer allowed to work, legally speaking. So then, how do you support yourself? So make sure that you have enough savings while you are entering towards the 5th year or 4th year at wala pa kayong grounds for a waiver or your waiver application is still on process. So whether you will incur unlawful presence because that's a risk, or you will be working without authorization and the government finds out, that's fatal situation that you will be in. Even if your employer will be able to file an H-1B for you, and the government finds out that you work without authorization or you've been unlawfully present in the US, they could still deny your H-1B. Now, it's a different story if you're applying for a green card. So, even if you are unlawfully present, but your unlawful presence is not more than 180 days, then it's still be able, as a lawyer, I could still be able to argue based on rules that the unlawful presence is not more than 180 days. So, pwede pa rin makalusot yun, no? So, but if you are married to a U.S. citizen, don't worry about the unlawful presence or the working without authorization because exception to the rule that if you are married to a U.S. citizen, you are considered as an immediate relative and your violations will be forgiven by the government. Okay? So what's next now? And this is my last slide. If you are not subject to the 212E, I would recommend, and may nagtanong kanina, no, na if you are not subject to 212E, then talk to your HR and your school districts to start the H-1B for you or the green card process for you. Kasi kung hindi pa sila nag-start ng labor certification, the labor certification could take 2 years to 3 years. So habang naghihintay kayo doon, you are still on the H1. And on H1, you are allowed to stay for 6 years. No? So you really have time. But start that conversation now if you are not subject to the 212E. Ngayon, if you are subject to 212E and meron kayong waiver, again, talk to your HR, talk to your school district that they might be able to convert your J1 to H1 And then the school could also start the green card application process for you. Um, dahil may waiver ka na. No. But however, yung mga walang waiver and they are subject to the 212E, sometimes it helps to accept the reality na wala ka talagang waiver because by reason of age or any medical condition, hindi ka na talaga manganak or you are no longer getting married to a US citizen or a green card holder spouse. Then accept the fact that your stay in the United States on a J1 is limited to 5 years, or if the government will still give an extension because of the COVID, then you might be on the 5th year, 6th year, 7th year, or 8th year, and then that ends. Kung wala ng extension, kasi you have no ground for a waiver. But if you are in that situation, start convincing your employer to start the green card application for you. Para kung uuwi man kayo, habang naghihintay kayo doon, after the 2 years, you will already be waiting for your interview at the embassy for your green card. So win-win situation pa rin kahit na magsakripisyo ka ng 2 years. So again, that ends my presentation for today, and I hope I was able to give guidance on how you would transition from J1 to H1 to a green card. And I'm just going to answer some of the remaining questions here before I officially end my Facebook Live. And again, thank you very much for almost 300 live viewers for today and for staying with me while I answer the remainder of the questions. So Piang, is it allowed for J1 teachers on her first year to transfer to another school in another state? If the school is within the jurisdiction of the same sponsor, yeah, you may. And if they would allow you, then you can. But if you would transfer to another school on a different sponsor, that is not advisable because you might be subject to another program, subject to another 2-year home residency requirement. Noel, pag nagkasunod po sa 2-year home rule, kailan pwede mag-apply ng H1B? 2 months before boss? 2 months before mag-expire yung 2-year mo, you could basically reach out to your employer and file the H1B for you. Because then again, your H1B application can be premium process and it can be approved in 2 to 3 weeks. Linlin, Nick, good evening from Cagayan de Oro. What if i-waive ng J1 as a teacher dahil merong offer ng H1, new employer, but not as a teacher, but as a healthcare professional? Okay, what if i-waive ang J1 as a teacher dahil merong, okay. So again, if you are not subject to the 212E on a J1, and then may nag-offer sa'yo ng H1 on a healthcare professional, so let's say nurse ka, again, there are rules for H1B now, for nurses to get a better success of being approved, dapat nasa specialty area ka, no? But let's talk about healthcare professional in general that would fall into the H1B and you are not subject to the 212E. Yes, you can apply for that if you are not subject to. But if you are subject to, then kailangan mo pa rin ng waiver before you can transition to the other profession. J1 visa holder as a teacher, I want to adjust my visa EB3 as USRN. I have already an employer. Again, if you are not subject to the 212E, yes, you can basically successfully transition from a teacher to a nurse. But if you are subject to, then you still need a waiver. Micaela, I am an international student and took LLM in a law school in New York. Unfortunately, I wasn't able to go to NY last year due to the pandemic and took up my classes remotely in the Philippines. I'm planning to pursue another degree in NY this fall. Can I apply for work there while on F1 visa and convert it to working visa? Okay, so Micaela, no? So again, good luck on your pursuit to become a lawyer in the US. So kung natuloy lang sana yung LLM mo, your program actually allows you to apply for your OPT. This is the practical training after your master's degree. And then you are eligible to apply for a work permit. So in that context, you could basically work legally in the United States. No, there is also another exception to the rule where a student visa can be allowed to work. So example, you are enrolled in the LLM and then after your first year, you would be able to argue that there is potential severe financial difficulty on your side because your sources of income has faced some challenges. Then you could also talk to your designated school officer and apply and get a recommendation that you will be able to apply for a work permit. And that, if that's approved, you would also be able to work legally in the United States. Now, ngayon, ang sinabi mo, I'm planning to pursue another degree in the US for as long as it is a degree course. What I said in a few minutes ago can still apply, no? So after your first year and you're facing potential severe financial difficulty, you could still apply for your work permit based on that ground, or you could also apply for your practical training, whether while you are still in the program or after the program. So good luck on that one. What if you already applied for a waiver, married to a U.S. citizen spouse, and you were denied and your program ended already? Okay, so it really depends on what's the ground for the denial, though. So once you get denied, you still have the option of filing a motion or an appeal. So once you explore that, um, I would really recommend that you consult a lawyer to explore your other options, because once you get denied, it's very difficult. If once you are denied on the merit, it really depends. It's really difficult to use the same ground, no? Pero kung na-deny ka because you failed to respond to RFE, I think there's still a way to argue with that. You can still file a motion to reconsider or to reopen, or worse, file an appeal. I am not subject to 212E, but my J1 visa stamp has expired. Is it possible to process H1? Okay, so kung ang visa stamp lang ang nag-expire but you were given a new DS 2019 extending your stay, then hindi ka talaga out of status. So in that regard, you can apply for H1B assuming that you are not subject to the 212E. But if you are subject to, then you cannot apply for H1. Then the only option for you is to renew your J1 at that point. Bryce, so again, last three more questions, and I would say thank you to everyone, right? Because overstaying na ako. But again, thank you very much. So Bryce, what is the percentage of having approved kung meron kang US citizen child, and how long is the process? So even in the cases that we handle, no? So we are very upfront with our client to say, any lawyer should not be able to give you guarantees that your case will be approved, even if the track record of the lawyer is they have high percentage of approval, right? Walang guarantees yung lawyer. But in the case that we handled, we say, the only guarantees that we could say is we will give the best representation that we have or we can, because at that point, hindi pa namin alam yung case mo. So I would not be able to answer your question of what percentage, because I don't inquire into the other lawyers' track record as well. No. But the process-wise, it could take 9 months to a year. Okay? So that's how long exceptional hardship waivers take sa ngayon. Nueva, can I apply for J1 visa if I have a valid C1D visa? So if you are outside the United States, of course you can apply for a J1 visa. But if you are in the United States on a C1D, you have a very limited stay in the US, I don't think that you'll be able to transition from C1D to J1. I recommend that you would talk to a lawyer to get better guidance. Alfie, and two more questions left. Nag-file po kami ng 5-3 extension. What will affect for a J1 visa? So, if you are on a B2 and then you apply for a J1 because you find a sponsor, then you would be able to transition that for as long as the application was done outside the 90-day prohibition for you. Else, they might find you on fraud route. Maurice, from your firm, meron po ba H1 before sped in New Mexico? I cannot answer that question directly, but yes, we have a lot of clients in New Mexico, and there's a lot of school districts hiring in New Mexico for as long as you have a license. So, ma'am, kausapin mo lang yung mga staff ko as to the opportunities, no, sa New Mexico. We are not a manpower agency, but we try our best to put your resume to them, but they will contact you. So we don't pursue that, but we'll give your resume to them, and good luck on that one. Last question. If willing po ang employer ng H1B visa holder na i-hire for a teaching position ang kanyang H4 dependent, kailan po maaari magsimula at magtrabaho ang H4? So, if H4 sila, and they are willing to harden H1B, the H1B can be processed in 2 to 3 weeks. Once that's approved, then they can they can start working with the employer upon the validity of the H1. So, good luck on that. And, sige, one last na lang. Sony, is it possible for two Filipino J1 teachers to get married in the United States, then have kids after the marriage? if mag-pursue po ng H1 in the future, given that background, may mga disadvantage po ba if ang ground for waiver is exceptional hardship na nagkaroon ng US citizen child? Okay, so two question scenarios here. Is it possible for the two Filipino J1 teachers to get married? Yes. Can they bear a child? Of course, right? That's one of the reasons why they got married in the first place. Ang ayaw mo lang mangyari is at the time, the third question, can they use the child as a ground for exceptional hardship? Yes, generally speaking. Can they use that ground to apply for no objection statement, assuming that the Philippine EVP will change their rules? Yes. Ang ayaw mo lang mangyari if you apply for the exceptional hardship based on the US citizen child is to say that we plan to bear a child so that we can use that child as a ground for the US, for the exceptional hardship. Then 100% your waiver application will be denied. No? So, ang recommendation ko is once that happen, I really recommend that you consult with a lawyer, immigration lawyer for guidance. But to answer your question, generally, yes, you can. So again, marami pang mga questions na hindi ko masagot and I apologize if I cannot answer them. But next Facebook Live, hindi pa naman tapos. Just try to be early and raise your questions right away so I could answer them. Okay? And again, maraming salamat po and thank you for watching. Good evening po. Bye-bye.